Are you going to send out a standard order or pretrial
Yes.
order? Okay, thank you.
Okay.
Warren, see you later.
My understanding, we have a protocol? Yes, let's have here.
Mary Alice Gwen on behalf of plaintiff Norman Lanson and Barron Stores, Inc. Morning, Norman.
Meryl Lanson, pro se.
Frank Colinelli on behalf of defendants, the Reed and Bernhardt defendants.
That's a live case. In the other case,
Do I have it?
Yes.
yes, you do.
Okay.
It
I
got
know there are a number of cases.
Yeah, our case is 99-21062. It was dismissed many years ago. I'm here on behalf of Ron Coplow and Coplow and Flynn, PA. Robert Klein, I'm sorry.
Lori Ross, Chuck Throckmorton. We both represent Mark Cooper and Wolf.
In that same case, Charles Andrew Tharp on behalf of Sonia Salkin and the law firm Malkin Salkin.
Your Honor, in the 2006 case, Dania Saavedra on behalf of the offshore defendants.
Do I have everybody? Okay. All right. Now, everyone can see. I read the case management reports. The 99 case was dismissed.
Correct.
And summary judgment and out, and then they took an appeal, and all the appeals were dismissed.
The live case is the
Would you like the case number, Your Honor?
yes, please.
Okay, it's 2006-09516 CA 20, section 22.
I think the 99 case, at least for purposes of anything that may have to be done with respect to it, has been transferred to me now. Correct? Correct. Your Honor, it's on the motion. Okay. All right. Now, my understanding is that Ms. Lanson wants to revisit the 99 case. And I'm not sure that there's any real basis to do that. That's one that Judge Jerry Cohen had a hearing.
She dismissed it on two bases, on summary judgment because of res judicata with regard to certain bankruptcy court orders which were provided to the court, and also for failure to comply with various court orders. That was affirmed by the Third District in multiple respects. It was ultimately, the appeals were dismissed.
There was never an opinion on the merits, Your Honor, and the appeal was dismissed.
It was dismissed by the third.
By the third.
It wasn't a voluntary dismissal. It was
No.
dismissed by the
That
third.
is a dismissal on the merits. On the merits.
Your Honor, the case, there was never a brief sent to the third DCA. I never had access to the court. She never had subject matter jurisdiction. There's due process violations. The crux of everything that went on here is that my husband, Barron's, and I were fraudulently induced into engage in an agreed order to compromise, which was reduced to an order by Judge Stetton, and it was very clear that the defendants could amend their affirmative defenses, and then we could go in on a motion to strike under 1.150, their default summary judgment or the like. Judge Stetton ordered it. We never got the hearing. We asked for the hearing dozens of times. Judge Cohn wouldn't give us the hearing.
I thought she spent 3 days in trial.
Never.
That was in the bankruptcy court.
Bankruptcy court.
We never had a trial in bankruptcy court on the fraudulent documents. That was the fraudulent. What they've been saying to you is that we had a trial on the bankruptcy court for 3 days before Judge Hyman. That never happened. Judge Hyman had a trial on the first fraud that they committed in 2007. And what the defendants did is they used the findings of his 2007 case, which was on failure to disclose connections, And they tampered with his order to comport with the 2008 finding that the bankruptcy of Barron's was confirmed using fraudulent documents. And that's what they did. And Judge Hyman even said, we gave you his orders. Judge Hyman admitted he never gave us a hearing on the fraudulent documents because it wasn't necessary because Barron's preserved all of its claims against the attorneys. Yet these attorneys, we never got a hearing on the 1.150, and they managed to get summary judgment on the very claims that Judge Hyman says was preserved.
Would you like to see Judge Hyman's order?
I have it right here, Your Honor.
Well, Judge
I'd
Hyman,
like to look at Judge
Which
Hyman's
one?
order that you're showing.
Oh, please show it.
seen it 17 times. They moved to reopen the bankruptcy. There were two fraud issues that they raised. The first fraud that they raised was raised in front of Judge Gerstein, and they claimed that Judge Hyman had been defrauded by the lawyers because there were all kinds of conflicts of interest that hadn't been disclosed. Judge Gerstein said, look, I'm not going to overrule a bankruptcy court finding. If there's fraud in the bankruptcy court, go to the bankruptcy court. They did. We tried that issue for 3 days in front of Judge Hyman. Judge Hyman found no fraud, and he sustained and did not reopen the bankruptcy court case. They then came back in front of Judge Hyman in 2008, and they asked to open the case back up again because they had this new theory of fraud. That the bankruptcy plan had been forged, and as a result, a critical exculpation clause had been removed, and it prevented them pursuing their claim. And if you look beginning on page 7, when Judge Hyman denied that emergency motion to reopen the case, he said, we don't need to go there. And we don't need to go through all of these machinations because the exculpation clause that they're referring to actually would have limited their claims against the professionals post-bankruptcy, assuming there were any. And the removal of this exculpation clause could not have caused them any harm. That's on pages 7 and 8 of this order. And by the way, they've been backing before Judge Hyman yet another time on a motion to reopen the case, and he summarily denied it.
That was June 4th of 2004.
I never filed a motion. I want you to be honest.
Excuse me.
She sent a letter
Letter to
to
Judge
Judge
Hyman.
Hyman, which he treated as a motion to reopen and denied in a written order served on all of us on June 4th, 2014. And with respect to what happened with Judge Hyman's original order on fraud, they appealed that to the Southern District of Florida. Judge Cecilia Altanaga affirmed. Then they appealed that to the 11th Circuit Court of Appeals, which also affirmed. So then we're in front of Judge Cohen. Judge Cohen enters a summary judgment in the case on two bases. One, the res judicata of all of their claims, and she entered a series of summary judgment orders. But the very detailed one we're referring to, which is entered January of 2009, was twofold. Number one, summary judgment on all of their claims as a matter of law by virtue of what happened in the parallel bankruptcy proceedings. And number two, an alternative motion dismissing the case for noncompliance with court orders in a very, very detailed order in which she found that Meryl Lanson was holding the system hostage and had failed to comply with court orders. That's at page 19 through 27. We gave you the January 6, 2009 order, which is very detailed. They filed an appeal to the 3rd District Court of Appeal of that order. They were ordered by the 3rd District Court of Appeal to do many things, including filing their briefs. Instead, they filed a series of motions, including motions to vacate because the orders are void, motions to transfer the case to another system in another state, in another galaxy. I'm sorry, I'm being sarcastic. But they wanted it anywhere but in the state of Florida. The 3rd District denied their motions and ordered them to file briefs. They refused to file briefs. They continued to file motions. Finally, in 2011, in January of 2011, the 3rd District dismisses their appeals. They filed more repetitive motions for rehearing and motions to disqualify judges on the 3rd District Court of Appeals. The motion for rehearing was denied. Different judges substituted in every time they tried to disqualify other judges, but they ended up with final orders dismissing the appeals. And now Then they came back, Mrs. Lansing came back, all of this is in front of you, Your Honor. We've got copies of everything. Mrs. Lansing filed an emergency motion to vacate the judgment again in front of, that ended up in front of the division judge, who was Judge Rodriguez.
June of
2013. He denied it without a hearing, that motion to vacate. So it was 2 years between the dismissal by the 3rd District, 2.5 years, the dismissal by the 3rd District and the first motion to vacate being denied. And now we're back, and Mrs. Lansing has told us all she's going to be here forever. That's what the pleadings say. She's never going away.
Your Honor, on behalf of the plaintiffs, I have to say, if these orders are void, regardless of the appeal,
How could all these orders be?
because they never had the right to due process. There was an order. What happened, Your Honor, previously they entered an agreed order to allow the defendants to amend their affirmative defenses. And there was a condition. They can amend them as long as Judge Stetton put it in an order. Go ahead and amend it. Plaintiffs reserve all rights to challenge the amended affirmative defenses, including but not limited to the motions to strike, motion for summary judgment, and the like. Their previous counsel, as soon as that, who negotiated that agreement with these attorneys, followed up with a motion to strike the affirmative defenses as a sham pleading under Rule 1.150. That counsel withdrew. I came in and I tried to set that hearing. Never heard that hearing, and under the rule, it mandates an evidentiary hearing. So for the short period of time that I represented the plaintiffs, and I would like to give this to the court, this documents all the times I tried to get an evidentiary hearing. May I approach, Your Honor? It's a listing of all the, I took pages out of Mrs. Lansing's motion to void, all the times we tried to get an evidentiary hearing that's required under the statute. And I attached Judge Stetton's order that preserved their right to do so, and I also attached the previous counsel's motion to strike the affirmative defenses as a sham. Their whole summary judgment was based on those affirmative defenses. The plaintiffs never got a chance to challenge it. That's what this whole thing about, and that is why those orders, dispositive orders of Judge Cole, are void. Lack of due process. And if I could just...
But you appealed it, right?
Your Honor,
Appealed?
Your Honor,
Yeah.
we filed a writ of mandamus to have the 3rd DCA send it back to the lower court because she didn't have subject matter jurisdiction, Judge Cohen. She denied us due process. The Florida Supreme Court, 11 days before I had my right to reply, denied it. I filed a writ of mandamus. They filed a response. According to the rules, I'm entitled to file a reply within 20 days. It was denied even at the Florida Supreme Court. But, Your Honor, we didn't have any due process. You know what? I am getting really anxiety because this is all about the agreed order to compromise. They induced us, fraudulently induced us to fight so they could amend their affirmative defenses 87 and 88, and we have a right to then challenge it. That needed to be heard. 1.150 mandates an evidentiary hearing. You can't do anything until you get an evidentiary hearing. We were begging her for the evidentiary hearing. She wouldn't give it to us. Those 87 and 88 is the fraudulent documents. When they say fraudulent documents, Judge Hyman's order specifically says whether there was fraud or not. Barron's hasn't shown how they were harmed. As a matter of fact, they're in a better position. All of the damages against the attorneys have been properly preserved. They managed to get summary judgment on the very damages that Judge Hyman said were properly preserved.
The court here, I'm reading from the order, the court concludes that rather than harming the movements, the deletion of the exculpation clause benefited the movements by eliminating provisions that could have protected the attorneys rather than the parties. He goes on in the order.
I want my hearing.
He said all of them were preserved, properly preserved.
Okay. I'm not sure I can do anything on the 99 case, but I'll read it. Now let's deal with the 2000.
Can I just provide one thing to the court?
I'd like to provide all the times we try to
Both
get
of
in.
you show each other
I
what you're
gave them
giving me.
copies, Your Honor.
Your Honor,
Thank you.
what's really disturbing me even more now is that we have two motions to strike their responses as shams. They said in their motions, they manipulated Judge Hyman's orders. They played with orders in addition to everything else that they've done. The law is very clear. 1.150 mandates an evidentiary hearing. 1.540B4 mandates an evidentiary hearing. But I can't get an evidentiary hearing from anybody?
Ms. Lanson, I'll read it and I'll make it.
The only reason I gave you that order is that if you look at Ms. Lanson's chronology that she just handed you and all the discussions that were going back and forth between counsel, when they had counsel in January 2008 forward, and there were motions to strike filed. If you look at Judge Cohen's order on the status conference that was held by the court on May 30th, 2008, the plaintiff moved for leave to amend, and she granted them after 9 years, an amended complaint was filed. And the order said that the leave to amend will move to plaintiff's pending motion to strike affirmative defenses. So, this whole notion, and by the way, I'd be glad to give you the motion to strike. The motion to strike the affirmative defenses had to do with a Fabre defense. That's what the motion to strike was. It was filed by Mr. Osho and company, who are now
No, it was filed.
defendants.
Right.
No, it
Leave to
wasn't.
amend was granted. It shall be served by August 1, 2008.
Leave to amend was granted by who?
Judge Cohen.
She never
She
allowed us
never allowed
to.
us to amend.
She never allowed us to amend the complaint.
We never even saw that. She never allowed us to amend the
It's
complaint.
right here, but
Well, we never got it.
Well, I can show that we didn't because I can show you the transcript and the order on it.
this was the order on May 30th, 2008 status.
The order was dated June 23rd, 2008.
Your Honor, additionally, when they talk about the fabrication of the bankruptcy plan, we have an expert.
All right. Okay.
Well,
I'm sorry. I'm going to read the materials and then I'll do what I need to do. Now let's talk about the 2006 case.
Thank you, Your Honor.
Who's here on behalf of the 2006?
Counsel for the Reed and Bernhardt defendants.
Okay, great.
Counsel for the Osho defendants.
Mary Alice Gwen on behalf of plaintiff Norman Lanson and Barron Stores, Inc.
and Meryl Lanson, proceed.
Okay. Tell me the status of the 2006.
Your Honor, we had a hearing in front of you, I believe it was on December 17th of this year, or 2014, and it was on plaintiff's motion to vacate an order entered by Judge Gales lifting the stay, and it was based that Mr. Colonelli basically misrepresented to the court that the plaintiffs just didn't show up. He didn't tell Judge Gales that we filed a motion for protective order, that we sent him a couple emails and letters back and forth saying that we had a conflict. And Judge Gales entered an order, but in the transcript he said if the plaintiffs come back and challenge it, I understand that Mrs. Lanson lives quite a distance away and there's some health issues, I'll hear it. You had, I think it was quite a long hearing. That's when the court decided to reopen the 99 case because the stay couldn't be lifted until all of the matters in the 99 case had been dealt with. And I have a copy of the order, if you'd like, that you entered. I may approach.
exactly what the claims are with respect to the defendants.
The complaint that was filed? Your Honor, I think it was just a bare bones complaint, knowing that this particular matter was going to be stayed until the 99 case was determined. I wasn't representing the plaintiffs back then, but if the stay is lifted, we would move to amend the complaint.
So the 2006 case is stayed?
It's been stayed.
We disagree. This case was filed in 2006. What was ruled back in 2007 was that the claims asserted in this 06 case, the cause of action did not accrue because there was no redressable harm. And there was no redressable harm until there was an underlying final ruling in the 99 case. So our case.
Do you have a position with respect to whether or not there was a final ruling in the 99 case?
Well, yes, we do. There was a third DCA opinion entered in 2011, and since that third DCA opinion was entered,
Was it an opinion or a dismissal?
Well, it was an affirmance of the dismissal of the 99 case,
Okay.
which has been argued by other counsel.
Okay.
So since the time of that appeal, the defendants in this case, since 2011 through 2014, had been making every effort to get the stay lifted in this case because redressable harm was found as of the date of the opinion in the appeal. And it took us nearly 3+ years through various efforts of scheduling hearings, the plaintiff's unavailability, their health conditions, flat out refusal to want to attend hearings. Eventually on April 23rd, we set the matter for hearing. This was after plaintiff had filed additional emergency motions to vacate the 99 case, and Judge Gales was the presiding judge at the time. He needed some time to look into what the 99 case was about because they're now trying to, make representations to the court that they should have this opportunity to revisit the vacating of the final orders in the 99 case. Well, when Judge Rodriguez entered his order in May 2014, basically revisiting those issues in the 99 case and ruling that he was not going to reopen the case, we brought this to Judge Gale's attention, and he ruled at that hearing that he was going to lift the stay. The order was entered, lifting the stay, and the defendants had filed a joint motion to dismiss on May 3rd, 2014, and now the plaintiffs are here arguing that the hearing on the last motion to lift the stay was improper, that I personally lied to the court and made misrepresentations at that hearing, all of which I deny and take very seriously. There were no misrepresentations. Plaintiffs refused to attend that hearing. It was adequately noticed. Everyone was on notice, including counsel. Opposing counsel for Barron's did not even appear at this hearing. And the judge understood that notice was adequate and everyone had appeared. And we even have a transcript on that hearing. So if the judge even would request or would like to review that transcript, we can again file it for your review if that's necessary. So, it's our...
Why don't you do that?
I'm sorry?
Why don't you do that?
We can, Your Honor.
All right. Now, you want to amend your complaint? You have a motion to dismiss pending.
That's correct, Your Honor.
You want to amend your complaint?
But, Your Honor, you have ruled on our motion to vacate that order based on the misrepresentations of opposing counsel. All the exhibits were attached. Letters to Mr. Colonelli stating that I was not available, nor was my...
Regardless of that, do you want to amend your complaint?
Well, yes.
Okay. I'll give you leave to amend.
So do I understand you're denying our motion to vacate that order?
Well, do you want the stay lifted or not? Do you want the stay in place or do you
I want the stay in place until we deal with the issues of the 99 case. Because that's what the case law says.
The case law entitles me to I don't understand how we could sit in a court of law. The law says under 1.150 we mandate an evidentiary
All right,
hearing.
let me
We
have
never
the
get it.
transcript of what transpired in front of Judge Gales. I'll review that. I'll review your motion, and I'll decide. I may just allow you to re-argue it. I'll just have a re-hearing on it if everything's okay, and then we'll move forward from there.
Well,
Yeah.
if I might just add, the whole reason for the stay was because there was no finality in the 99 case. So if there's finality in the 99 case, there's no reason
I'm going
for
to
a
answer
stay.
the order with respect to that as
Okay.
well, and then we'll be able to see where we go in 2006.
And Your Honor, just for the record again, and we pointed this out to the court previously, they keep referring to Judge Rodriguez's order. Judge Rodriguez never had a hearing. He just summarily said he didn't have any authority to consider vacating another court's order. So he never reviewed the merits, and there's never been a hearing or any type of evidentiary hearing on the motion to reopen based on void orders. And they keep bringing these appeals up, and if they're void orders, it doesn't matter. They can appeal it forever, and it's still void.
And Your Honor, you said the same thing at the last hearing. You said he denied it without a hearing. That's what you said at that hearing.
Okay.
Are we not allowed due process in the court of law? I enter into agreements with the defendants that they get an end of the bargain, and I don't get to enter my end of it and speak at an evidence. I am just totally confused as what our rights are as citizens when the law is really clear about what a 1.150 and a 1.540B4 stands for. They just, why do you even have plaintiffs and defendants? Why don't the defendants just say what they have to say and the judge stamps it and that's it? Everything they said here is continuing lies. They're continuing to lie and they get away with it. Void is void. Declare versus Yohanan is right on point. It says if you engage in a false promise to compromise, it's rendered void. It's a Florida Supreme Court case, and it cites Throckmorton. And that's what we did. We entered into an agreed order to compromise. It turned out to be false because they got their end of the bargain, and then they shut us out and sat silently. And Judge Jerry Beth Cohn said a half a dozen times, I don't care if you come begging on your hands and knees, I'm not going to give you a hearing on the fraud. How many times do I have to tell you you're not going to get a hearing? How could you tell people they're not going to get a hearing?
Your Honor, may I approach you asked for the motion to vacate on the 2006, and that was the Judge Gales ruling, and the transcript is attached as an exhibit.
Okay. You want
We want to actually,
Take a look.
we want to send you a copy of the entire town transcript. I don't know if it's... I
It's
think
in there.
The entire, because I know...
Why don't you take a look?
Yeah.
Thank you.
Judge Gales even said at the
All
hearing,
right. Now let me say also, if you need to in the future, I have no objection to appearances by telephone.
no, I can't, not even after seeing something like this. I am just,
Ma'am,
it set me
I'm
back.
just telling you.
I appreciate that.
If you need it, or if your husband wants to appear.
My husband is very ill. He can't even comprehend this. He's very ill.
I understand. Okay, folks, I'm going to take this under advisement. Court's